Okay, super. Thank you very much. It's a real pleasure and honor to be here with you. I would have liked to have come in person and have been in Valencia yesterday for the soccer match, although it didn't end up as you, I guess, expected. But anyway, it was a good soccer evening and a good preparation for today's talk, because I guess a lot of people will have ordered their pizzas and beers for watching soccer at home via an internet platform. I'm not sure I can progress. Yeah, super. I will not get too much into the kind of setup of platform work, because Adrian has talked about this and you have had this on the first day. Just to wrap it up, what I would like to talk about today is the European level. So we get one step up higher from what Adrian has told you about Spain. And Spain is a really interesting case, because in Spain we had first decisions in the global case about the platform economy and the legal status of platform workers. And secondly, we have this riders law, which for the first time in Europe undertook legislative action to take at least a stand on some issues of platform work. What I would like to talk to you about is what is the status quo on the European level, and what are the projects envisioned concerning platform work. If we look at one of the last labor law directives concerning precarious work, actually, and there's a history of the European Union in regulating atypical employment relationships, because especially the European Commission, who has the right to initiate legislative action, has seen now for more than 2 decades atypical work as an issue, especially when it comes to precariousness. And the last directive, the directive on transparent and predictable working conditions, is actually the kind of restatement, the amended directive, which used to be the information directive, but now was extended to substantial rights. And interestingly, when it comes to extending substantial rights, especially fighting precarious, unpredictable working conditions that come with the famous, or you could say infamous, zero-hour contracts in the UK, it was clear that we had to also think about platform workers as a group of workers that are there's a risk of precarity. And interestingly, if not doing this explicitly, even but in the recital, we have the mentioning of platform workers, which makes it impossible for member states to exclude platform workers just because they are platform workers. It says more or less, if they fulfill all the criteria of a worker, then they have to be covered by employment law and may not be excluded. There's a second, not only directive, but regulation on platform work, which is what we call the P2B, the platform to business regulation, which does not cover platform workers, persons within an employment relationship, but which covers self-employed persons, undertakings that provide their services via a platform. And you can see by those bullet points that the idea is they are business users, there is a platform, which is called an online intermediation service, and there are consumers. What is not covered is business to business, but only business to consumers. And Again, it's very much the European approach about transparency, but there's also interesting issues concerning the access to data, and especially the prohibition of offering different conditions through other means, which means if you're offering your services via one platform, there has to be a justification why there are restrictions that you're locked in with that platform. In the end, what is still open is we have some regulation on precarious work. Yeah? We have some regulation of self-employed platform workers, but what is still missing is to have regulation for those people who are considered working in an employment contract. And in 2019, when the new commission was taking over under the lead of Ursula von der Leyen, we had on the one hand side in her political statement, on the other hand side in her mission letter to the Commissioner for Jobs, Niklas Schmidt, we had explicit mentioning of platform workers that there will be some kind of legislative action. In a way, this is the kind of flagship project of the European Commission when it comes to labor law and working conditions. And we are now in the second stage consultation of the social partners concerning some legislative action concerning platform work. I've given you the links for the consultation documents and also for the staff working document, which is quite extensive, more than 130 pages. In a way, the consultation document and the staff working document gives you an extremely good, very condensed overlook on the status quo of the discussion in Europe and elsewhere. I will now go in the following slides, in the remaining 15 minutes or so, I will discuss the consultation documents. It's very likely that the social partners will not follow this up, which means that they will not reach some kind of social partner agreement on the European level, but the Commission will take over again, and it's expected that by the end of 2021, the end of this year, we will have a proposal for a directive by the European Commission. I will now go into the consultation document, which I only can recommend you to read through. It's very accessible. The language is not too scientific, so it's actually a pleasure to read, I would say. What are the challenges according to the European Commission? And the first and foremost challenge is the employment status of those persons providing platform work and the resulting obligations of the platform. So the employment status, this is kind of the core problem, and we see in all the jurisprudence Adrian has pointed out for you that it's always about employment status. Are they employees and the platform is their employer, and thereby minimum wage laws, working time legislation applies, or are they self-employed and you can pay them as little as you want and have them work as many hours as you want? That's the core problem. The second problem are the issues stemming from algorithm-based business models of the platform. And this is interesting because in a way, platform work is more a magnifying lens for all those issues we have in the traditional labor markets than something extremely new. In the end, it's about fighting precarious work. And in a way, platform work is the test case for how digital technologies can be used to increase efficiency, but on the other hand side, may also result in very unsure and precarious working conditions. Then we have the issues related to the cross-border nature of platform work. Platform work takes place also in the digital world. Even if you deliver services in person, the platform does not have to be based in the same country where the platform workers actually work. And there are, of course, issues related to it. And there might be some real challenges that are specific to platform work. But all in all, the European Commission concludes that poor working conditions and inadequate access to social protection is an issue. The employment status. So what actually happens is that platforms try to evade labor law, and all of them, or at least 9 out of 10, like 90% of the platforms classify all platform workers as self-employed. And we see with all this litigation going on within Europe, it's very likely that this classification is a misclassification, that platform workers are actually working under an employment contract in an employment relationship. And why is this the case? Because platforms decide unilaterally to regulate employment conditions. And platform workers, and Adrian pointed this out very well, their alternative is being unemployed and having no income, so they have no choice but to accept the self-employed status. And there is litigation, of course, but this litigation takes a lot of time and money, and platform workers are usually not in the condition to spend a lot of time and money on a job they very often only see as a transitory job. In Vienna, we see with bicycle couriers, the average time to stay with one platform is 4 months. And you don't fight and organize for better working conditions when you see that this is not a job you want to take on longer. And we see that there's reclassification in UK, France, Spain, and Germany, with all very important cases. And interestingly, in Italy, they went for third status. They said that platform workers, although they are not employees, they are subject to the protection of labor laws. And as Adrian also pointed out already, the platforms are extremely reluctant to apply the rulings consistently. So you need to take additional action. The challenges from algorithmic automated managers are the second issue, and the use of this algorithmic management is at the core of the platform economy. Recruitment, surveillance management, supervision and control, kind of everything that goes on a platform is automated management. You cannot administer and manage all those short-term working contracts without automatization. And of course, the algorithmic management is a big black box. Employees, platform workers just don't know what's going on. And so transparency about the algorithm is really an issue. How are decisions taken? The second issue, of course, is that there should be a human in control, and this is resulting from the GDPR. But even if a human is in control, it's not very clear who is actually responsible for what. And we have a lot of information asymmetries resulting from this, which kind of strengthens the power, the imbalance of power that is in favor of the employees, therefore the platforms. If we kind of take another aspect, it's the aspect of collective bargaining for the self-employed. And interestingly, here, this is an issue. Of course, we see good examples like in Spain, where the riders' law was a result of collective bargaining. But we see that in some countries we have an issue with collective bargaining, because if platform workers are not considered workers, they are not exempted from competition laws. And this is, of course, an issue, because then they may not collectively bargain for the working condition, as this might be seen as a price cartel, and thereby there is an initiative ongoing by the European Commission to ensure that at least European Union competition law does not stand in the way to improve working conditions through collective agreements for solo self-employed. In a way, it's considered they want to make a safe harbor, they want to clarify that collective bargaining, also for the self-employed, also for those platform workers who are not employees working in an employment relationship, is still possible. What's the consequence of these challenges? And here you see the European Commission says there are consequences for platform workers. On the one hand side, they have flexible work arrangements. That's what they like about platform work, but they have precarious working conditions and inadequate access to social protection. And this is very much a result of automated decision making that exasperates those challenges. Digital labor platforms, they face a regulatory patchwork within the European Union, and there's an uneven playing field, so they compete against each other on a very different basis, depending on the country they're actually based in. For markets and consumers, it's hard for small companies to start, for SMEs and startups to get a foot into the platform economy, because there's a lot of market concentration. As we see in the delivery sector, usually you have two large companies. The same goes for personal transportation. It might have negative effects, spillover effects on traditional businesses, because they come under pressure and there's uncertainty for consumers. And for the member states, due to the cross-border nature of platform work, enforcement might be very difficult. What could the European Union therefore do? And the idea is, actually they put out, and this is very interesting because it very much fits in with the Spanish writers' law, three objectives. One of them is the correct legal status should be obtained without undue obstacles. You should lower the threshold for enforcing your employment status. The second issue is fairness, transparency, and the accountability for algorithmic management. And the third issue, and this is always very important on the European level, we don't have a lot of data on platform work. On the one hand side, for scientific reasons, to have empirically based policy making. On the other hand side, of course, also for state and social security authorities. What could we do? And interestingly, the European Commission is not very clear. They put out a lot of options and say maybe we don't regulate all types of platform work, all business models, but only some. And as it is the case, for example, for the burden of proof in the Spanish writers' law, which is, if I understand correctly, only applicable to bicycle couriers. The second is the question of binding or non-binding instruments, if it's the directive, only a council recommendation, or even softer non-legislative measures. What is clear, and this is something the union fought very hard, they do not want to create a third status. It should be the dichotomy of employee, self-employed, and nothing in between. You get either all or nothing. But as you will see, there might be an extension. Misclassification is the major issue in the platform economy as it stands, and the options the European Commission points out is a rebuttable presumption of an employment relationship. So it says it's an employment relationship unless proven otherwise. Or you shift the burden of proof. You have only to provide prima facie evidence. There's a certain number of indicators. I think the Spanish writers' law works a little bit, works in this direction. You only have to prove certain elements, and then the platform has to prove that this is not an employment relationship. Another way is the question who enforces it. if there is maybe a lower level administrative procedure to examine the employment status and not the full-blown court case. Certification of work-related contracts is also an issue, and I think would make very much sense that the platform or a worker can have put in their contracts and a report of their working conditions, and then you will have an abstract decision if this is an employment contract or not. The second issue is algorithmic management, and interestingly here you see there's quite a lot on it, but in the end it's very much about transparency, about privacy for workers, and as you can see in one of the last bullet points, the promotion of ratings, portability, so that workers are actually mobile between the platforms and they are not locked in. Interestingly, this is also discussed if it should not only apply to workers, but also to the self-employed. So here you would see there is something kind of extending those rights beyond traditional work employment relationships. And the idea is we want to go beyond the platform economy. We want to use the platform economy as a test case and later go beyond it, as the Spanish law actually does. The cross-border challenges are immense, of course, and everybody who has ever taken a court case cross-border knows how hard it is. You see, there is always the idea that you would have something like a register for platforms, but on the other hand side, maybe also for platform workers, the introduction of the European Social Security pass, which makes it very transparent and evidence where you're actually covered by social insurance. A third issue is collective representation and social dialogue, which shows, of course, this is institutionally grounded as the European Union, or the European social model actually, is very much based on social dialogue. The idea is to involve the social partners at as many levels as possible. I now would come to a quick conclusion to leave a little bit time for one or two questions. Interestingly, and I think this links up very well with the presentation of Adrian, on the European level, the issues are seen as in Spain. One of them is the employment status. The second one is algorithmic management. And on the European level, it's also the cross-border nature of platform work and the idea that social dialogue is very helpful, especially when it comes to new forms of work. Thank you very much for your attention and for your interest, and I'm welcoming your questions if there are any.
So many thanks, Professor Gruber-Risak, for this really interesting explanation about how consultation, dialogue, and also confrontation between the interests of workers and the interests of platforms has been more or less evolving in within the European Union. I don't know if we have questions here on site or online. If not, there's one thing I really interested in knowing your opinion, which is beyond the fact of all this regulation about algorithms and how they may affect workers, and also beyond the fact of consider people working for platforms as workers or self-employees, the other side of this evolution is whether or not, if we consider them workers, the complete bunch of rights that traditionally we award to workers should be also be given to those workers, or if we have to tune a bit the list of rights, because maybe, for instance, I am a public law scholar, so from a public law perspective, it's quite clear, I think, that the evolution that we have already seen and the evolution that we can foresee for the near future is that in terms of social security, we are going to establish a different regime. We are going to tune a bit the situation, because that's work, but maybe a bit different. So in order to try to strike a fair balance, we are going to reduce some of the social security burdens. And well, it's that's more or less the idea, or at least that's what I can foresee. Is that more or less the same with social and labor rights? Do you consider that if we consider them workers, we should apply to them all the traditional rights, or that we can also make little changes in that?
This is, of course, a tricky question that has been discussed now for quite some time. And it comes to the one hand side, is the question, do we have to redefine the notion of employee? Do we have to redefine the personal scope of protection of labor law? And this is usually a discussion about personal subordination and integration into another's organization. As traditionally seen, is this enough to include all those persons in need of protection? And we see now in our discussions, there is a group that is formally autonomous, but economically extremely dependent. And these are these solo self-employed, these entrepreneurs without any employees. And they are the ones now where we discuss opening up collective bargaining for them on the European level. This is the discussion in competition law. If they are price cartel, or we might exempt them from the prohibition of restrictions of kind of market forces. And I personally think we have to kind of redefine the scope of labor law, and then we have to ask ourselves if there may be some persons, and I think of managers, who are traditional employees, but economically they are in a much better position. We have exempted them, for example, from working time laws. If you're an autonomous worker, if you're a manager at a certain level who can decide about his or her own working time, we exempt them. So, you know, we might not, and I would conclude with this, not only think about extending it, but of recalibrating, but definitely not at the low end. But, you know, if we want to recalibrate, we look at the managers who have it good enough.
Many thanks. I think it was clear, and I'm really glad to hear that labor law sticks to its foundations. You know, that's wonderful, because well, that's the idea, to protect workers. We have a last question. In this case, the question is an online question. Kamila Naumovic raised the hand. So if you want, you can already put your camera and your microphone on, and you can ask your question directly to Professor Gruber-Risak.
Okay, thank you very much. I am trying.
We can hear you, but for the moment we do not see you.
Okay, I'm sorry. I don't know how to give permissions to my video camera, but I will ask the question not to because I did it, so it's supposed to work. Sorry.
It's not a problem. It's not a problem because we can hear you, so you can ask the question.
Okay. So thank you very much for the presentation, Professor. My question, just to be short, was connected with the collective bargaining, because I'm an assistant professor of labor law in Poland, and in Poland since 2019 we have amended the collective labor law and gave the right to associate to people performing paid work, which is a new category that can also include solo self-employed. And since then we we still didn't have a lot of success in collective bargaining of those categories. So my question was connected with that, because the European Union is now thinking about, of course, the problem of antitrust law, and to give this right to solo self-employed, as we just did. But still, the question is how to execute this right in practice, and how to find the labor rights that they could bargain about. And of course, the other question is, and this is just an open question to know your opinion shortly, because we have a limited time, how to realize this right in practice if we decide to regulate it on a European level.
Yeah, thank you very much. And I think the first step would be opening up the right to collectively bargain for the self-employed. So there shouldn't be any legal obstacles, because what we have seen, and the Danish case is maybe the most well-known about the Hilfer, about the collective bargaining agreement with a cleaning platform that was challenged before the competition authorities. And we have the same issues, in the Netherlands, in Belgium. So these cases come up. So it should be clear that they may collectively bargain. And of course, it's hard because there's not a culture of solidarity within the self-employed. Workers learned it the hard way for more than 100 years that they can't compete against each other, especially on wages and working hours, because the only way they have to put in a floor. And kind of the mode of the self-employed is we are in competition with each other. We don't kind of fix our prices with each other and do not go beyond it. So 100 years ago, you would call this class consciousness. And even Karl Marx, he talked about the petit bourgeoisie, who did not understand the mechanics of the market, and that they would not profit from the mechanics of the market. So the second thing, of course, is that it's hard to organize them, and it's self-organization, it's voluntary organization. This is what collective bargaining is about. And we see, like in Germany, where we had a similar law for decades, where collective bargaining was allowed for, after the kind of 70s, 80s. We only see the only collective bargaining, substantial collective bargaining for self-employed going on was journalists working for television, national broadcasting companies. They had one big partner, and they were all dependent on them. And so I'm a little bit more optimistic about the platform economy, because we have these extremely large players, and I think that it must become clear for the platform workers, as it has for Uber drivers in the US, for example, where they negotiated in New York, or pseudo negotiated. It became clear that they have to have some kind of general agreement, so they do not compete against each other too much, but they have a floor of especially